Hello, my name is Crystal Dahl, and I am the Online Communications Manager here at Meritas. I would like to welcome and thank each of you for joining us on today's webinar, When Me Too Means You Too, What to Do When You're in the Sexual Harassment Hot Seat. For those of you that are new to Meritas, Meritas is an established global alliance of closely connected yet independent law firms that each offer a full range of high-quality specialized legal services. We were built upon a rigorous system for monitoring and enhancing the quality of our member firms and have been connecting clients with carefully qualified business legal expertise in over 240 markets around the world since 1990. Meritas Capability webinars are regularly presented by Meritas members. Before we get started, I'd like to quickly go over a few housekeeping items. Meritas now offers the ability to listen to our webinars through your computer speakers, but if at any time you have difficulty hearing the presentation, you may also call into the associated telephone line instead. All phone lines will be muted. If you experience any technical difficulties, please press *0 at any time to connect with a support technician. Since you will be muted, if you have a question, please ask via the chat feature found on the left-hand side of your screen. Rob and Kirsten plan to answer questions throughout the presentation. Lastly, in the next few days, I will distribute a copy of the presentation, a recording of the webinar, as well as the presenter's contact details. Our presenters today come from the Meritas member firm in Cleveland, Ohio, Corman, Jackson, and Krantz. Rob Gilmore is Chair of the Litigation Practice Group and the Labor and Employment Law Practice Group at Corman, Jackson. Rob counsels employers large and small in the full range of labor and employment matters, including workplace terminations, reductions in force, employee handbooks and policies, non-compete agreements, trade secrets, shareholder disputes, unfair labor practice allegations, union negotiations, and general business litigation. He represents employers in state and federal courts, arbitration, and before state and federal administrative agencies in defense of employment discrimination, wrongful discharge claims, and in non-compete litigation. As a former Assistant General Counsel for Verizon Communications, Rob brings understanding of both sides of labor and employment disputes. He is a frequent speaker on labor and employment topics and is a fellow of both the College of Labor and Employment Lawyers and the Litigation Council of America. Kirsten Mooney is an associate in the Litigation Practice Group at Corman, Jackson, and Krantz. Kirsten assists KJK attorneys in preparation for a wide variety of legal matters, providing support with drafting litigation documents, deposition preparation, and other client issues. She is also responsible for conducting substantive research in case law and statutory legislation, both in Ohio and in states across the U.S. Much of her work at KJK focuses on labor and employment matters. With that, Rob, are you ready to get started?
All ready. Thank you, Crystal.
You're welcome.
Thanks, everybody, for being here. I think we're going to have a fun hour here going through Me Too, what that means in the workplace. And really at this point, the Me Too movement doesn't need a whole lot of introduction. All we have to do is check the paper every day, to the extent you're still reading a paper, or check online every day. You see something new, really almost every day, be it in new state laws, new individuals being accused, and workplace policies changing. So really, since the fall of last year, maybe even earlier, with Harvey Weinstein, it has just been a tidal wave of issues that have sort of coalesced around the concept of hashtag Me Too. And it's certainly not going anywhere. In fact, I think it's building steam. It's creating a lot of risks and liabilities and dangers in the workplace. And I think even more than going back to my early days of practice, where you had the Clarence Thomas hearings with Anita Hill, you then had President Clinton and Monica Lewinsky, which created a lot of uproar in the sexual harassment area, and certainly it became a common phrase, and a lot of things were done in the workplace. This has created, I think, far more awareness than all of that put together. And I think it's a complete change. there needs to be a change in how companies view this and how they handle internal complaints to avoid these lawsuits and the resulting PR risk now that I think is greater, frankly, than it's ever been. There's always been a risk for employment litigation, not just sexual harassment, for really any employment litigation, that it's extremely costly, it's uncertain, it leads to a huge amount of attorney's fees, it's a great distraction in a company where people's resources end up being spent in conference rooms with lawyers like me, Kirsten, and many of you on the phone. But that doesn't help. That doesn't help your client. It doesn't help the business. But what now I think is different than really it has been in the past is one misstep can drastically alter a company and can potentially take a company down. And so being aware of that, handling things from a PR and communication standpoint has never been more important. And I was just reading the other day about I think it was Nike, where it was called a women's revolt, where a number of executives came forward to the CEO or the chairman, I don't recall, to say that there's a boys club and there's an inner circle of men and women are excluded. And apparently an investigation was done, and in the end of it, I think 6 very high-level employees, including I think maybe the brand manager of Nike, left the company. So this is it's a huge issue. I've even seen derivative actions from plaintiffs' lawyers trying to attack a company for not responding appropriately to sexual harassment and saying, hey, the stock price of the company has gone down, and create shareholder derivative actions based on this. So it's prevalent, and we'll spend time today dealing with it. My thought on all this is not to say in any way that corporate America has been asleep at the switch, because I don't think that's the case. I think that from when I began doing employment law to now, I think things are very, very different, and I think that most companies do a good job of saying that sexual harassment and other harassment isn't okay. I think that back in the 90s when all these issues came up with Justice Thomas and President Clinton, a lot of things were changed. But I do believe that maybe over time companies have become complacent. I sort of call it, we've gotten into a bit of a check-the-box mode. All right, every year we need to do training, or every 3 years. All right, it's a necessary evil. Let's bring somebody in. Let's do it. Maybe it's even done on computer. It's just something that has to be done, but we don't want to spend too much time with it, and we'll do the same thing every year. We'll send out the same policy. And I think that now this is a wake-up call, and we have to really look closely at what companies are doing, what our clients are doing, to make sure that we have a fresh view of this in light of the MeToo movement and everything else that's going on. And Kirsten will get into some of this later. There have been certainly negative consequences and some backlash and confusion, which we'll try to deal with, where I've had people say to me, hey, I don't think I'm allowed anymore to be in a conference room alone with a woman. I don't want to go to a business event with a woman alone because I'm afraid there's going to be issues. So there's all kinds of things floating around, and people are trying to figure out best practices, and we'll deal with some of that today. All right, so let's moving on. Again, the agenda for today is we'll very briefly talk about sexual harassment in the law. We're not going to spend a lot of time just sort of droning on as a law professor telling you what the law is, but we'll spend just a little bit of time to a baseline of what sexual harassment is and isn't. Kirsten's going to go through some of the public perceptions currently with a lot of great statistics that are recent, showing perceptions of men, of women, of companies, which I think will be very enlightening. Kirsten will also spend some time going through the MeToo movement and the TimesUp movement. Again, while I think everybody certainly knows what's going on. I think it'll be helpful to see some chronology and timeline and see some of the things that have been happening and put it in perspective and in a timeline. Then we'll show you some of the new federal and state laws, and frankly, they're changing weekly. Just in the last few weeks, New York, Maryland, the state of Washington have come up with new laws. I think New York City, and there's some provisions in the federal tax laws that are actually worth your review, which we'll go into. And finally, and I think maybe most importantly, we'll spend time talking about what employers should be doing, preventive actions and remedial actions. So how to prevent all of this from happening on the front end, and then if there are issues that arise, what do you do about it to avoid getting sued or to at least deal with the issue or get something resolved without too much difficulty. And again, if there's questions, please feel free to put those out there, and we'd be happy to deal with those as we go. As I think being interactive would be the best approach here. So with that, we'll move on to sexual harassment in the law, and again, just to more set a baseline for what we're looking at here. I think in general, it's pretty well understood that the two types of harassment, of sexual harassment, is quid pro quo and hostile work environment. And those phrases get tossed about a lot. But quid pro quo, a fancy Latin phrase, but it basically means that somebody in a position of authority or power is trying to demand something sexual in return for an employment benefit. I'll give you a raise if you go out with me, if you sleep with me, and or the negative of that, if you don't submit to my request, then maybe things won't go well for you at the company, or you won't get a position, or you'll get the worst job. So that quid pro quo is the most difficult for a company to get around. If a supervisor is doing that, it's difficult to legally sort of find an easy way around it. That's why training is going to be the best way to deal with that, to make clear where the lines are. Hostile environment is it can be one action, but usually it's a series of events. If it's really serious, it could be one thing, an action that was so outrageous and offensive that could on its own create a hostile environment. But often it's many comments over a period of time, a constant discussion or emails with sexual jokes or the like, or lewd comments. So it doesn't have to require any change in a person's work, so you don't have to have a demotion tied to it or anything like that, or a failure to promote. It can just be that the environment itself is created a hostile environment. Now, when I talk about these phrases, for the most part, I'm dealing with federal law, and we no doubt have lawyers from all over the country. And of course, federal law is going to apply everywhere. Now, state law, depending upon your state, may or may not be as significant or more significant. In Ohio, we frankly see more cases in state courts under state law than we do in federal court under Title VII or the other federal claims, because of Ohio's very strong state statute that gives a private right of action, and people don't even have to go to the EEOC. But the good news is that for the most part, Ohio, and I would imagine other states that have strong discrimination statutes, more or less model the case law of Title VII. So again, not making this specific to any state, and for the most part under federal law. One unique thing in Ohio that may or may not be the case in other states is that individual supervisors can be sued for sex discrimination, sexual harassment, while you can't be under federal law. So moving on from there, probably the most difficult claim to defend against, frankly, is retaliation. I find that it's a lot harder for a plaintiff, for an employee to prove the underlying sex discrimination or sex harassment than it is to show at least perceived retaliation. Because with retaliation, all somebody really needs to do is say, I engaged in a protected action. Maybe it was an email to your EEO department internally. It could be something to HR, to EEOC, anything that's claiming that there was harassment or discrimination. So now you've set that in stone, and there it is. If something happens to that employee in a negative way, they're fired, they're disciplined, soon thereafter, while it doesn't absolutely prove the case, it creates certainly an easier claim for an employee to say, hey, I was retaliated against. On this day I complained. A week later I was fired. So it doesn't mean the person is in a super protected category forever, but you better have good reasons. So if there's a layoff coming and this person maybe thinks that they're going to be involved in it and they make an allegation, don't ignore the allegation. Review it, investigate it, close it out, be sure you've looked at everything, and then if there's an employment action thereafter, try to separate the two and show that one has nothing to do with the other. I've seen many cases where one side of the company doesn't know that an investigation is going on, and the other side then takes an employment action. And well, again, you can say, well, the manager didn't know. You might have to prove that after months of litigation and costing $100,000 or more in court. So it's best for everybody to be on the same page and to understand before they take any serious action. And retaliation, as it states there, can be any number of things from termination on down. And one of them that you see a lot is the last bullet point there, isolating the complainant. So I defend in a lot of cases where an employee says that after they complained, they were shut out of meetings. They were sort of frozen out. They weren't fired. They didn't lose any money, no bonuses, no salary, but they were no longer at the table. And over time, they then feel that they're out on an island, and I've seen some where people quit and claim it's a constructive discharge to say they're no longer in the key decision-making authority. So it doesn't have to just be a firing. It can be anything that is a sort of a term and condition of employment that somebody is something's happening to them, possibly because of their conduct. All right. As I mentioned before, on employer liability, so when there's a supervisor involved, that's known as vicarious liability to the employer. So that in essence, an employer is going to be directly liable for sexual harassment when a supervisor is involved. Certainly, if there's been a job action taken, if the person was demoted or didn't get a promotion or was fired, if the supervisor is the bad guy here, you're not going to have an easy defense to that. On the other hand, if there is no tangible employment action, so it's a hostile environment allegation that the person hasn't been harmed in their position, you do have a defense. The Supreme Court cases listed there on this slide, Farragut and Eller, back from the 90s, when all of this was at the forefront at the Supreme Court, created an affirmative defense to basically say, look, if you, the employer, have done all the right things to try to prevent harassment, policies, training, etc., and the employee didn't take advantage of that when they could have, they knew about it, it was in the handbook, they'd been told, they'd been trained, and they didn't follow through, you may be able to get out if it's a hostile environment and not a quid pro quo, and it's also not a tangible action that's happened to the employee. So that here's my thought on that, is that with the MeToo movement, this is where I think maybe we've all got complacent to say we can certainly get this defense if we have the policy. Everybody has a policy now, in their handbook, a sexual harassment policy. Everybody may roll it out every year. It may be even an onboarding of employees, may or may not be, and there may be training done periodically. It may be a higher bar in the future. It may be that that's not enough. Now you need to do more than that. You need to not just have a rote computer training. Maybe it has to be live. None of this is set forth in stone. I'm not saying that any court necessarily has mandated this yet, but I think that this will become an area of exposure for companies in trying to get this defense if they're just sort of doing the same old thing they've done before. I think people need to step up their game on this one. And finally, on this issue, before I turn it over to Kirsten, it's important to remember third-party liability, meaning that if your employee has contact with a client, a vendor, a service provider, a customer, you can't turn a blind eye if they are being sexually harassed by that client or vendor. And while I think maybe we all know that, that hasn't gotten quite as much publicity or play through the years. Maybe sometimes it would be, well, what can we do? It's not our employee who's doing this. It's some client, and client comes first. And maybe not to say that your employee should have to submit to sexual favors, but maybe a company might say, hey, that's not much we can do about it. We don't want to ruffle feathers. We don't want to hurt our client relationship. What if it's a son of the CEO of your client and is asking out one of your employees, and they don't want that? You get into this difficult spot where, oh, geez, we can't damage our employment or our client relationship. I think the law is going to turn a little more to say you've got to protect your employees. And the old saying of, client comes first, of course, but that doesn't mean it can be at the expense of your employee. So I think it's another area we're going to see a lot more activity going on. And this case that's mentioned in here, which is Hurricane Grill. Just briefly, this was the EEOC coming after the franchisee and owner of a restaurant where a group of female servers had repeatedly complained to the manager about harassment from a regular customer. And the guys had been commenting on their body and groping them inappropriately and even soliciting them for sex. The manager took no action and eventually fired this server, and the EEOC, on behalf of the employee, which is rare, took the case to federal court and said that the restaurant owner had allowed this workplace environment to become intolerable, and the suit eventually settled for hundreds of thousands of dollars. So I think this is going to be, you're going to see more of this as we move forward. And with that, I'm going to turn it over to Kirsten, who's going to move into some of the statistics now.
Hi, everyone. So in these next few slides, you'll see that we've included some statistics for you regarding the public perceptions of sexual harassment. On this slide, on the graph on your left, you can see the number of women who reported experiencing sexual harassment in the workplace. In the summer of 2017, approximately 22% of employed women said they experienced sexual harassment. This increased to 30% in October 2017 and to 35% in November of 2017. However, in October of 2017, an NBC Wall Street Journal poll also found that while 30% reported experiencing sexual harassment, only 90% of women said they formally complained about it. Moving on, we have a comparison chart showing the differences between what men and women believed to be sexual harassment. This first slide is taken from a late October 2017 poll by Barna Group. And while I won't go into every single one, you can see that men and women's opinion of what is considered sexual harassment differs. 96% of women and 86% of men say touching or groping is sexual harassment, and 58% of women and 47% of men say persistence in asking someone out on a date after being told no is sexual harassment. So there's no chart here, but I guess that's a technical difficulty. But this was a November 2017 poll by YouGov. The differences are still clear. 60% of women and 50% of men say wolf whistling at a woman is sexual harassment. 55% of women and 38% of men say looking at a woman's breast is sexual harassment. And 29% of women and 25% of men say that a man commenting on a woman's attractiveness directly to her is sexual harassment. Ultimately, I think what we can see by these polls is that the public sees more aggressive or threatening behaviors as harassment, but flirtatious or verbal actions less so. So how should sexual harassment be handled in the workplace according to the public? 44% of Americans think it is inevitable that men will hit on women while at work, and 86% of Americans believe that zero tolerance policies are our best shot at bringing about change. However, a poll conducted in October 2017 seems to find that Americans can see some type of bright line. 5 years ago, almost 75% of Americans believed that a woman who reported being sexually harassed was risking her career, but today only 44% believe so. And similarly, approximately 2/3 of Americans believe that reports of sexual harassment were generally ignored 5 years ago, as opposed to the 26% who say they are generally ignored now. So perhaps largely resulting in the bright line is this MeToo movement. In 2006, Tarana Burke coined the phrase MeToo as a way to help women who had survived sexual violence. She originally set up MeToo as an activist group, and she would promote during workshops geared towards young, mostly high school age girls. Currently, Tarana is the Senior Director of Girls for Gender Equality at a nonprofit organization in downtown Brooklyn, New York, and she still promotes MeToo on a regular basis. Some of you might not know how this MeToo movement began or reignited today. So just a little background. On October 5th, 2017, Ashley Judd publicly accused Harvey Weinstein of sexual assault and harassment in the New York Times, and afterwards many joined Judd in coming forward with their own allegations against Weinstein. About 10 days later, on October 15th, Alyssa Milano, an actress, responded to Ashley Judd's allegations on Twitter. Her tweet simply said, quote, "If you've been sexually harassed or assaulted, write me too" as a reply to this tweet. And by the end of the weekend, more than 40,000 people had responded to her tweet, and more than 12 million people had engaged with the hashtag across social media platforms. So almost overnight, Milano reignited or sparked an entire movement. We've included a timeline for you, some of the most popular MeToo allegations out there right now. And I won't go into detail about all of them, but as you can see from the timeline, the movement has created a snowball effect, with many of the most powerful men being accused of these types of allegations, both in the private and public sectors. The timeline we have provided is a mere sampling of the many claims that have been made, as it seems almost every day another one comes out. The most recent one, I guess, is Tom Brokaw from NBC. He is the most recent victim of the movement, as allegations of sexual harassment have sparked media attention once again. The next slide is just a quote by Tarana Burke. You get a chance to review it. So another movement that has begun to gain some speed, not quite as popular as the MeToo movement, is the TimesUp Movement. It was announced January 1st with an open letter on behalf of more than 300 women in film, television, and theater that ran as a full-page ad in the New York Times. It's spearheaded by many of Hollywood's biggest names, Oprah, Ashley Judd, who originally accused Weinstein, Kerry Washington, Jennifer Aniston. People don't know that it began as a response to a national alliance of more than 700,000 female farm workers. The alliance penned a letter in November of 2017 expressing solidarity with women and men of Hollywood who have experienced harassment and abuse at the hands of their employers. So what is TimesUp, and how is it different than MeToo? TimesUp establishes a legal defense fund to provide subsidized support to women and men who have suffered from sexual harassment in the workplace or while pursuing careers. It encourages Hollywood studios and agencies to strike a 50-50 gender balance of power. Importantly, it spells out the definition of sexual harassment for all, and it's a pledge of solidarity that frames survivors as a unified group. Most of you probably saw this during the Hollywood Awards season. It was very present, and it has a big presence on social media right now as well. So the implications of the movement have been both positive and negative. In any event, I think what we all can agree on is that the movement have created permanent changes as to the way the United States treats sexual harassment. Some of the positive implications: the movements have destigmatized sexual harassment. Women are much more comfortable coming forward with their stories, and it gives them a platform to stand on. It has shifted discussions in the workplace as to what is and what's not okay while on the job. And it demonstrates that sexual harassment is ever present and it's not distant. Some negative implications: some people believe that the movements have gone too far. A group of 100 French women published an open letter accusing the movement of lumping merely flirtatious men with harassers and abusers. Actor Matt Damon agreed and came forward, stating that there's a spectrum of harassment and not everything should be seen as the same or lumped together in the eyes of the movement. And most notably, there's been some consequences in the workplace that nobody expected to happen. The demise of mentoring relationships between men and women. Men are now uncomfortable taking on female proteges out of fear and concern. One study found that 64% of senior men avoid solo interactions with junior women in fear of rumor about their motives. And the number of men who say they're uncomfortable mentoring women has tripled since the MeToo movement began. Rob also touched on this, but the avoidance of one-on-one contact with women has become a problem. Men are no longer willing to be alone in a setting, whether that be meetings, dinners, traveling, and sometimes they do so subconsciously. They might not even know that they're excluding the women from doing some of these things. And there has also been an increase in sexist hiring practices. Executive men are not hiring or promoting women as a fix to the problem of sexual harassment complaints.
All right, so moving on to some of the federal and state regulations. You know, one of the places you wouldn't have expected to look to see something about sexual harassment probably would be the new federal tax law. But there are some surprises in the tax bill, and this is one of them. So if you, as a company, settle a case where there is a claim of sexual harassment or sexual abuse, and interestingly, neither is defined, at least at this point, in the new tax law. Regulations, I don't believe, have come out on that. At some point, I would hope that it's defined, but right now it's not. But if you settle a case, and as part of that case, you demand, or you have a non-disclosure clause in the settlement agreement, which you always do. I always do in every case, not just sexual harassment. Frankly, just about every litigation matter I'm in, if it's resolved, if I'm on the defense side of it, it's just a standard clause in almost every case where you would say, all right, the company's paying you X amount of money. You're going to agree, as one of the, besides agreeing not to sue, you're going to agree not to disclose. You're going to keep it confidential. But if you do that in the context of a, quote, sexual harassment or sexual abuse claim, the settlement is not deductible as a business expense. while it would be for potentially for any other discrimination. So it's a bit of an odd law. I think probably where it came from was, if you recall, back in the fall, there was a lot of talk about Congress, the various Congress people, senators settling cases, and those not being open to disclosure, and that suddenly people were surprised, and oh my gosh, all these claims were settled. And my own feeling is that that's probably where this came from. I've got some questions about it, which will be fleshed out over time. But one of the biggest I have is, if it's your normal case, and let's say there's a sexual harassment claim, there may also be a tort claim saying intentional infliction of distress, or in Ohio we have a wrongful discharge in violation of public policy claim, or maybe there's a breach of contract, or many different other claims might be in the lawsuit. There might be 8, 10 claims, or if you're in California, you might have 20 claims. So interestingly, that if you settle that case, and one of the 6 claims or 8 claims is a sexual harassment claim, can you apportion out the money and say part of it is deductible and part of it isn't deductible? We don't know. That one is wide open to interpretation. So we're going to have to see what comes out of that. I've even read some articles that say that the way the law is written, it's possible that even the complaining party, the plaintiff, might not be able to deduct her attorney's fees as part of it, where they would be able to in other cases, which certainly wouldn't have been the intent, because that would be putting a burden, I would think, on the complaining party. But some of the scholars who have written about it have said it's subject to interpretation, and we'll have to wait and see. So that's an interesting one. And also, last point on that is, I don't know that it's going to have the desired effect. If the desired effect is that we want to make sure that companies don't have non-disclosure agreements anymore, I don't think that's going to happen. I think that companies will still require, as part of a deal, you must keep this confidential, and deal with the fact that it's not deductible. It could even have a very unintended consequence, which there could be situations where a company says in the past, where this was deductible, I could pay X, but now, since it's not deductible, it's sort of costing us double, I can only pay less. So, that certainly was not the intent of this law, but I wonder whether it's going to serve its purpose. But we'll see in a minute when Kirsten gets back. Some states are now taking up the torch on this issue and of non-disclosure. So I don't think it's going to be going away. And this is what the federal tax bill did, but we'll see that some states are doing things too. The other thing we're seeing a little bit is some trend that companies may be moving away from mandatory arbitration for workplace harassment claims. And with that, I'm going to turn it back over to Kirsten, because that segues nicely into something that New York is doing right now.
Okay, so like Rob said, in response to the increase of sexual harassment complaints and allegations, several states have enacted laws or passed legislation significant to employers. New York, on April 12, 2018, the governor signed into law a state budget bill, which makes big changes in the obligations of New York employers. Effective immediately, the law will extend protection to certain non-employees in the workplace, which can include contractors, subs, vendors, consultants, and other persons providing services per contract. That means that the employer will be held liable for sexual harassment of these individuals if the employer, its agents or supervisors, knew or should have known that the non-employee was subjected to sexual harassment. There's also a few rolling provisions. On July 11th, 2018, employers will be prohibited from using NDAs and harassment settlements unless the complainant prefers that it be confidential. The settlement agreements must also give complainants 21 days to consider and 7 days to revoke. Employers may also not require mandatory arbitration of claims of workplace sexual harassment to the extent that it's not inconsistent with federal law. The Federal Arbitration Act, something that we probably run into, I've run into a lot, and so you have probably too, is a law that could potentially preempt this New York law. We obviously don't know yet. It's sort of unclear, and case law will definitely be needed to figure it out. On October 9th, 2018, a mandatory training provision will go into place. Employers must distribute anti-harassment policies in the workplace and conduct annual anti-harassment training. The training must include several things. It must include an explanation of sexual harassment, examples of conduct which could constitute unlawful sexual harassment, information concerning state and federal statutory provisions concerning sexual harassment, and information concerning employees' rights of redress and all available forms of adjudication. On January 1st, 2019, employers who wish to bid on certain state contracts will be required to first affirm that the employer has implemented a written policy. On April 11th, New York City Council also passed some legislation, the Stop Sexual Harassment NYC Act. This is a comprehensive package of legislation, and it's aimed at strengthening New York City's sexual harassment laws. Washington, the state of Washington has also joined in. On March 21st, 2018, its governor signed into law several new laws, which notably restrict an employer's ability to require NDAs concerning sexual harassment. The law specifically prohibits employers from requiring employees to sign as a condition of employment an NDA preventing them from disclosing sexual harassment occurring in the workplace. The law also, though, includes a carve-out exception for confidentiality provisions contained in settlement agreements. So the new law will still allow negotiation of NDAs in the wake of threatened or actual litigation. And as of a few days ago, the newest state is Maryland. Maryland's legislature recently passed Senate Bill 1010 through the Senate, and now it awaits the governor's signature. The bill provides victims of sexual harassment additional workplace protections. However, it's kind of different than the other ones. The bill requires that employers with 50 or more employees electronically submit certain information to the Maryland Commission on Civil Rights on or before July 1st, 2020. This information must include the number of settlements made on behalf of employers after allegations of sexual harassment, the number of times the employer has paid a settlement to resolve a sexual harassment allegation, and the number of settlements made after an allegation of sexual harassment that included a confidentiality provision. The weird little twist, though, is the information will be retained by the Commission for public inspection or upon request under the Maryland Public Information Act.
Okay, the EEOC has also gotten into the mix as well, and they came out November 22nd of last year with enforcement guidance on unlawful harassment. It was a lengthy study. It wasn't sparked by the MeToo movement. It had been going on for a while, their study, and it's a lengthy proposal. Well, I don't necessarily suggest you need to read the whole 75-page draft. It is worth taking a look at the summary because I think it's helpful to again have a fresh look at how to prevent harassment. And while I don't always agree with the EEOC, and there are certainly times I would be at odds with the EEOC, I think it's worth at least taking a look at this. I don't know that I would go as far as to say that this, I would call it best practices. I think some of them certainly are, but I would take a look. The 5 key measures, I'm not going to go through too much, but number 1 is the strong, committed leadership, and that over and over again is seen as one of the key issues. Meaning, where's the tone being set? How is the tone being set at the top? And this is absolutely critical. And again, it can't just be, it's a check the box kind of a thing. There has to be leadership at the top. The regular and proven accountability, meaning that basically the system they put in place works. HR investigates people, there are issues, heads roll if bad things happen. They don't just circle the wagons and support the company. Now, on the other hand, they shouldn't be making snap decisions just because there's an allegation. But you've got a system that's accountable. Strong harassment policies. I'll talk about that a little more in a minute. And then reliable complaint procedures. And what they talk about there is not just in the handbook. It says, here's our complaint procedures. Everybody has that in their policies. I've written a zillion of them and read many others. But that it's truly a fully resourced part of the company. So that there's a complaint, there's somebody who can do something about it, who's a professional, or you go outside and bring in an attorney or a consultant or whatever it is you're going to do. But you're fully resourced. You welcome and encourage people to come forward if there's an issue. You have then very prompt and thorough, neutral investigation, and you protect privacy to the extent possible. You certainly can't guarantee people who complain about sexual harassment any privacy because you can't guarantee that at all. You very well may need to discuss that with other people, but you protect it as to the extent possible. And finally, the training. And what's mentioned there is that the best training is live training, and not just, hey, again, go in your office, put it on the screen, and click, what sexual harassment A, B, or C, and while somebody is doing other work or eating lunch. The thought is there should be live training. So that's worth a read. And then finally, before we get to our last section, the ABA at its mid-year meeting, their House of Delegates also approved a resolution, which you can find as well. It's worth taking a look at. All right, our last section is what should you do? How do you deal with this? And sort of broke it into two places, two categories: preventive actions and remedial actions. And again, as I said earlier, I would strongly encourage sort of looking at your clients or your, if you're here from a company, your own policies, and say, here's how it's been done, but let's see, is there a better way to do it? You don't have to necessarily do it the same way. The goal being not just that, okay, we've had everybody check the box and they've been trained, but how do we make sure the culture is the way we want it, make sure people truly understand where the lines are, have training that really gets to the key issues. I've done a lot of training through the years. I've sat in training. There are times when the training maybe people are sitting there sort of giggling and laughing and, oh, this is sort of a joke. Again, not to say that that's typical, but it needs to be a fresh set of eyes to say, how can we make this work, and how do we show that we're doing the right things? So, as I said, setting the tone at the top is critical. And one of the things here, as we see, the risk now is so great in this area as to one horrible situation creating major damage publicly to a company in the media. It again doesn't have to be Starbucks and the biggest company in the world. It could just be your own client in your own municipality that suddenly the local newspaper is going after because of a particular issue. It can be a huge damage to the company. The culture can be such then that maybe you can't attract employees as much. People view it as a place they don't want to work. There's so many implications that it's worth, at least my own view, it's worth putting enough resources into this to make sure that the message gets out there. So setting the tone at the top, encouraging employees to speak up. I would strongly suggest implementing the 1-800 hotline kind of a thing, because while those were all the rage for Sarbanes-Oxley and those kinds of issues in the public company setting, it really is a good thing to do at any level, any size of a company. Because while, again, we all have the policy that says if you have an issue, you can go to your manager. If you don't want to go to your manager, you can go to the next level up, and you can go to HR, and you can go to the CEO and the board, and all that's true, and all that's good. But I find a lot of cases people say, the employee says, yeah, but I knew I couldn't do that or I would be fired, and because it happened before, and I knew a friend who did that, and then they lost their job. And so allowing an anonymous hotline can be a very helpful way to go. Putting in somebody who's designated, maybe as the company's ombudsman, so to speak, for these kinds of issues, so that there is somebody accountable reviewing these things and dealing with it. So I think that's something I would strongly suggest. Then you get to your policies and procedures. Certainly a zero tolerance policy may make sense. I think there's a lot to be said for that. Of course, what does that mean? Zero tolerance? Is it you don't tolerate somebody being flirtatious? So what is it? Everybody has to define what does that even mean. But I guess to me it means violating the sexual harassment policies. And again, just sort of low-level things may not do that. So by no means am I suggesting that people willy-nilly be thrown out of companies for making a comment or making a joke. Training is critical. Let people know where those lines are, and that's why, again, the training part is so important. And in the policy, in the past, I think we've all reiterated the EEO policy and stated here's our view on sexual harassment. Make it easy to read and understand. But I think most important, provide a convenient and reliable mechanism for reporting, which might be this 1-800 number if all else fails. And as well, I think it's important to set forth specifically in the policy that this will apply to a third-party situation. So, if you're with a client, with a vendor, sexual harassment is not okay, and we will do something about it. More preventive actions. Again, we talked about training and how important that is. And with the training, particularly with supervisors, it's important not to just limit the training to the workplace, but also talk about business trips. I can't tell you how many cases I've had or issues I've had where there was a sales convention out of town. Everybody got together. They were at a hotel. There was a lot of drinking, and then all kinds of allegations come flying out of that. Holiday parties, sports events, go into the company loge, and people are drinking, or there's a client there, and the client starts getting a bit out of control. So dealing with that and letting people understand, again, where those lines are, where conduct is not allowed, and trying to address those issues. Other things that I think we seem to have a slide missing here. It's interesting. Well, this slide was supposed to say love contracts. So some of you may have heard about a love contract, which is a consensual agreement for an in-office romance. And I've drafted a bunch through the years, and it again, not saying this should be a wholesale use of it, but in some situations it can work where both parties would sign to be sure that that they have entered the relationship willingly and neither is being pressured. And it certainly seems maybe at first blush sort of over the top to say, oh my goodness, we've gotten to the point where we have to have people sign a love contract. But in the certain contexts, it might make sense. I've had these situations with a CEO and dating somebody and wanting to at least protect that, hey, this is all above board, not an issue. It's not completely fail safe. There can be issues, but it's worth considering if it makes sense. But and one other thing actually that was I wanted to mention, companies may look at their employment agreements with executives to relook at what the cause provisions are. So in many C-suite employment agreements, it may say that an employee, an executive, can be fired for cause, but in only a narrow, limited circumstance. So maybe it's fraud, embezzlement, conviction of a felony, something along those lines. I'm seeing some companies now consider, call it a bad boy clause, or a clause that says if you put us in a bad light, we can terminate you for cause. So I think that's something at least to ponder on the unemployment agreements. I think that's going to become more prevalent. And again, the other part of this slide that was supposed to be there was really just saying educate, 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 because this is there's really nothing more important than that. Moving on to our again on third-party harassment. Mentioned this before in terms of the legal issues, but being sure that you take those actions right away, that you don't let this go. You contact the third party to say, look, one of your employees is potentially harassing our employee, and it's uncomfortable for our employee, and we need you to do something about it. And keep pressing if they don't. You can't force them to do so, but you can certainly do everything you can to push them to do the right thing there, to at least investigate, and and maybe not have that person coming to your facility, so that you're doing the right things. And with all of this, it's very important on the legal side to document what you're doing, because later on, if you claim, well, we got in touch with that company, but there's no record of it. There's no email, there's no letter. It's just who said what, and you may not have any real proof. And as we all know, in court, people forget or worse, and so it's best to be absolutely clear in writing. The last few slides deal with remedial action. So you've had a complaint. How do you respond to that? And most importantly, of course, is to take it seriously and to investigate right away. Don't let time go by. Jump on it right away. And as well, one of the fine lines is the allegation just the employee doesn't like their supervisor? They're angry that they were given a performance improvement plan or a bad review, and there's really nothing there that is sexual or discriminatory at all. It's just somebody is angry and has sour grapes, and that doesn't require a full-blown investigation if it's just that. But if there's any hint of sexual harassment, or frankly any harassment, the focus on this today is sexual harassment, but if somebody comes forward with allegations of racial harassment, gender, disability, of course, really the same things need to occur. And the first decision after you decide, hey, we need to look into this, who's going to conduct the investigation? And I can spend a lot of time. I won't. The real two questions are, one, do you do it internal or external? And two, do you have a lawyer or not a lawyer? And the issue, of course, if you have a lawyer, you have the potential to have this under the attorney-client protection if you want it to be. You can always waive it later if you decide, hey, we need to defend ourselves, and here's the investigation we did. And if you don't have it done by attorney, then there's no attorney-client. But there's outstanding investigators who do this for a living. So you have to make those decisions about who to do it. And again, I won't spend more time given our being short on time. But to make sure you cover that the investigator covers the bases. It can't just be, all right, we talked to the complainant, we talked to the alleged the person who's alleged to have done this, and stop there. Maybe there's witnesses. Who else knows what's going on? I've done a lot of investigations, and a lot of the times it started with just one small complaint, and that ended up being just scratching the surface. And then once you scratch the surface, all kinds of things came out that were not known before. So it's really important to have a trained and good investigator who will cover the bases to make sure you've figured it out. Another important thing is, in all of this, it's important to remember, I'll use this term not in its constitutional way, but sort of the due process rights of the accused. So it's remember, you got to put your investigator hat on, or whoever's doing it has to not assume anything. So the pendulum can't go too far either way. It can't be that everybody is guilty until proven innocent, but it of course has to be that investigations are conducted appropriately. But people have to be given an opportunity to defend themselves, and many allegations are not true. I've certainly defended many and had many cases where I felt that the allegations just simply were either cooked up or overblown. And so it's critical to do that right, because of course at the end of the day you might get sued by that person who you fired. If you didn't do a good investigation and you fire that person, and that person comes back and says, "Hey, this wasn't appropriate," I think we'll see cases now a little more where maybe a man gets fired for certain things, maybe language, and comes back and says, "You know what? If I was a woman, I wouldn't have been treated that way. I think it's disparate treatment. I've seen women say the same thing to men. They didn't get fired, but yet I'm being fired for doing this." And I think we'll see more of that. So you got to be careful. You got to document, and you've got to have due process. I think we're right at our time, but I'll keep going as long as people are still there. In terms of how to respond, it's critical to don't let human nature take over, meaning that if somebody is accused of sexual harassment, it's natural for that person to be upset. I mean, let's face it, it's a weighty allegation, one that could ruin somebody's career, their life, their marriage. It's a heavy stick. And that individual, be it a manager, the CEO, HR, whoever, might be very upset. And it's important to keep that in check, and most important to not let retaliation seep in. The biggest mistake would be to try to retaliate, and the classic case would be to let the allegation comes in, an investigation is conducted, the manager gets a slap on the wrist, or receives some discipline, and maybe continues to manage that person. But then 6 months later, that manager suddenly starts writing up the person. Maybe not right away, but maybe it's 6 months down the road. You got to be careful. Again, not to say that if that person isn't performing, you can't discipline them. Absolutely you can. But you better have the goods on them. You better have good objective evidence that they're failing, and that it's not just looking like this person was angry and now they've bided their time and decided to take it out on the employee. Ultimately, you complete your investigation, and you have to decide as a company and with your client, if you're the outside lawyer, to what's the appropriate action. If harassment is not confirmed, you should still follow up with the individuals. You should remind those people to review the policy. Maybe you give it to them and say it's a good opportunity to review the policy, and at least consider whether it makes sense for any proactive measures like further training, like having people switch supervisory roles if there's a problem in the workplace. But closing the loop and reminding people of what's wrong, of what's right and wrong, but hopefully ending it there. If harassment is confirmed, then you've got to decide with the company and the lawyer what's the right thing to do. Is it a warning? Is it a suspension? Is it a demotion? Is it a salary reduction or freeze or taking away somebody's bonus? Or ultimately is it termination? And it's critical to follow up with the complainant to make sure they understand that something has happened, an investigation has been conducted, and to the extent you can provide that information, give as much as you can so it's clear that some remedial action here has been taken. If you end up terminating the alleged harasser, to reduce the risk of litigation, there's a number of things to do. I'm a big believer in getting waivers and releases. If you have any real concerns about the risk, if it's that person who's being fired is in a protected category, and you feel like it's maybe a little fuzzy, you feel like they did step over a line, but you're a bit concerned, you may get a release. You may provide a little severance just to be done. But it, of course, depends on the situation. You may decide, hey, we have a zero tolerance policy. You knew it. We think you clearly violated, and we're not going to give you any money for that. And other things you have to decide: will you fight their unemployment, or will you sort of roll over and let them get unemployment? Those are all decisions you have to make as part of the process. And it's very important to document why you're making the decisions, why you're laying somebody off or terminating somebody, so again you can later come back and defend what you did. And it's very important, no matter what the situation, to treat the terminated employee with respect. I always call it the golden rule. If you're being terminated, how would you want to be treated? And you want to give that person as much respect as you can. Last thing I'll mention, last slide. I briefly mentioned this before, but what I think is the game changer now is the potential PR concern. Again, it doesn't have to be the huge company. It can just be in your local community. You've got to be ready. You've got to be ready for the phone call from the media, the cameras going from the local TV station who shows up. You've got to be ready. You can't be caught flat-footed. You've got to have a plan in place. I think it's important to know if something happens, it doesn't just have to be a sexual harassment. It can be any serious issue, a product defect, any other employment case, something else that gets bad publicity, whatever it is. You got to be ready. Who's going to speak for the company? Don't be scrambling at the last minute. We see so often, the company could not be reached for comment, or the company said no comment, or nobody, or somebody does respond, but it's poorly managed and makes the company look bad. These are things that can be addressed. There's lots of good crisis communications firms out there. We've used a number of them, often in conjunction with lawyers. Sometimes they're competing advice there. Sometimes lawyers say very little, and PR wants you to get out ahead of it. You have to find where that balance is for your client, for your company, to decide what's the right way to go. But the best way to deal with that is in advance, not at the heat of the moment where calls are coming in and serious issues are being raised. Because again, the court of public opinion can be very unforgiving. So be ready for that. And I think that's all we've got here at Corman, Jackson & Krantz.
Thank you, Rob. Thank you, Kirsten. That was fantastic. We were truly blessed to have the chance to listen to you speak today, and thank you for rolling with the little technology glitch on those slides. Before we sign off, I just wanted to remind each of you that in the next few days I will distribute a copy of this presentation with all of the slides present, as well as a recording of the webinar and both Rob and Kirsten's contact details. Please do not hesitate to reach out to them directly if you have any further questions. With that, thank you again for taking the time to join us, and I hope everyone has a great day. Goodbye.
Thanks, everybody.
Yep. Bye-bye.